What's up, everybody? This is Mr. 100K a day, and today we're going to be reviewing a case that I personally did myself, and this is the case of Carlo Holmes. Carlo Holmes is a kid out of St. Louis. I met him personally about 15 years ago in 2009 when we both had a situation, and he had gone to trial. He had gone to trial for a case involving um, crack cocaine and felon in possession of a firearm. So I'm going to cut to the chase. So according to this is the actual memorandum that actually got what we did to get his sentence reduced. So on March 3rd, 2009, a jury found him guilty of both counts following a 2-day trial. And of course, those two counts were one count of possession with the intent to distribute in excess of 5 grams of crack cocaine, and the other count was felon in possession of a firearm. So after he was sentenced, he got 120 months. That was on each count, which is 10 years. And those counts were the sentence was to be served concurrent with a state sentence because he was on parole. Carlo had been in and out of prison probably all of his early 20s and basically all of his 30s. So, this particular situation he got caught up in, he wasn't even out a year and he ended up getting a 10-year sentence with the feds. So, a lot of people don't know that Barack Obama, I'm sorry, I can't even see the document. A lot of people don't even know Barack Obama signed a law in, I believe, in of September of 2010, and that reduced the penalties for crack cocaine, and it reduced it to make it so that if you had now 28 grams of crack cocaine, that's when you received a 5-year sentence minimum. Back then, the minimum was 5 grams before he signed the law. So people who ended up getting, 5-6 grams back then, if you had a prior drug conviction, they can eat, but they have a thing in the feds so they can easily double your sentence and end up giving you 120 months instead of 60 months, which is 5 years. So that was basically what he was going through. So of course, going to trial, he ended up winning one of the things on appeal, which was the gun charge, and that was it was basically on the confrontation clause because they violated his I believe Fifth Amendment right to confront his witness, to confront people who against him. So it was cool. It was cool, but him beating that one count, which was the gun charge, it was remanded back to the case, remanded back to the court. So it really didn't matter because he still had 10 years. He had 10 years on the drug charge, and he also had 10 years on the firearms charge. The thing was, him winning that on appeal, like I said, it really didn't do much for him. So he filed what they call a 2255 motion, which collaterally attacked his sentence. And of course, it says right here on September 28th, 2010, this court issued an amended judgment. And this defendant is hereby committed to the custody of the United States Bureau of Prisons to be in prison for a total of 120 months. Defendant is sentenced on count 2 to 120 months imprisonment to be served concurrently to any sentence imposed in any of his state cases, and they listed the docket numbers. So he filed this 2255 motion that collaterally attacked his conviction on the drug count on November 30th, 2011. So the case had been pending. So I pulled up on him. I ended up in my own situation. I pulled up on him 18 months later. You can see, I say when on April 29th, 2013, he moved to amend the motion. So what happened in this particular case, how I helped him win was he had already filed his 2255 motion. Everything had already been done. But when I read his paperwork, I noticed that Carlo, this is him now after he got out of prison and he's living his life now and, back in the hood in St. Louis. What I noticed was that when this amended judgment came out on September the 28th, 2010, the document specifically said that he was now sentenced. He is being sentenced. Defendant is sentenced on count 2 to 120 months. So that became his official sentencing date, not the date in 2009 that he was actually in front of the judge. And when they sentenced him, he didn't go back in front of the judge. They just sent them a document in the mail, said that, hey, your gun count had been dismissed because you beat it on appeal, and you're gonna stuck with 120 months. So he didn't go back before the judge. But I knew that in August of 2010, the law had changed, and it made the mandatory minimum for the amount of drugs that he had. It made the mandatory minimum a low. It made it 5 years, but it increased the amount. So basically, him getting sentenced in 2009 was for 6.1 grams of crack cocaine. At the time that the new judgment came out, where he got the new sentence because of him beating the one count, that same mandatory minimum was 5 years, but the amount of drugs that it took to trigger the mandatory minimum, in particular with his prior conviction, would be 28 grams and not the 5 grams that it was before. So I said, hey, man, hey, you need to change this. Add this on. Forget all the other stuff you're arguing on appeal, because you already lost your direct appeal. Forget all the stuff you're arguing on 2255. Just file this thing, and you have at this, now, mind you, this is 2013. He had already been in prison since 2009 on this particular charge. He'd been in jail since 2009 fighting this case. So I was like, hey, man, you get it down to probably 5 years. So this is where the judge picks up. He says, the judge allowed him to amend his motion to amend his 2255, and he withdrew all his other stuff, which was ineffective assistance of counsel, and the judge granted that. So the Dorsey thing was a Supreme Court case that came out in 2012 that said people who committed their offenses before Obama signed the law, but were sentenced after he signed the law, were eligible for the reduced penalties. So he was arguing, our argument was that he was eligible now for the reduced penalties that were applicable to the amount of drugs he had, which now would be only 5 years, which will only be 5 years in prison, because of the fact that, I mean, I'm sorry, he shouldn't be eligible for the 5 years, because based on the fact that he didn't have enough drugs to meet the mandatory minimum, the only thing they can really do is enhance him for having a prior. That's the only thing they can have. So instead of giving a mandatory 10, since he only had 6.1 grams of crack, he shouldn't have a mandatory minimum at all, really. And that was the reality. So let's go through this. This is the discussion of the judge. This is the judge's ruling. At stipulated trial, the amount of crack cocaine at issue in Holmes' underlying criminal case was 6.1 grams. Holmes' offense involving 6.1 grams of crack cocaine occurred in August of 2008. This was before the Fair Sentencing Act of 2010 took effect. After being found guilty in a jury trial, Holmes was sentenced on June 11, 2009. Because he had previously been convicted of a drug felony, he was subject to a 10-year mandatory minimum. The court sentenced him to a 10-year mandatory minimum. So on remand, following successful appeal of the 8th Circuit Court of Appeals, Holmes was resentenced on September 28, 2010. This resentencing occurred after the effective date of the FCA, which is the First Sentencing Act, August 3rd, 2010. That's the day that Barack Obama signed the law. But before the effective date of the new sentencing guidelines, under the First Sentencing Act, Holmes would not be subjected to a mandatory minimum, because 6.1 grams is less than the 28 grams that triggers the Fair Sentencing Act's mandatory minimums. Pursuant to the Supreme Court's decision in Dorsey, Holmes asked his court to apply the First Sentencing Act's more lenient statutory penalties to his sentencing. The Supreme Court in Dorsey held in Dorsey that the FCA, the First Sentencing Act, applies retroactively to offenders whose crime was committed before the FSA, which means the First Sentencing Act's effective date, but whose sentence occurred afterward. This includes offenders who were sentenced after August 3rd, 2010, but before November 11th, 2010, when the time period after the FSA's effective date, but before the new sentencing guidelines took effect. The Supreme Court's decision relied on 6 considerations. The first 3 considerations relate to statutory interpretation, background sentencing principles, and congressional intent. The 4th and 5th considerations the Supreme Court found relevant where avoided disparities in sentencing. The Supreme Court found unfair imposing upon the pre-act offender a pre-act sentence at a time after Congress had specifically found the Fair Sentencing Act in the First Sentencing Act that such a sentence was unfairly long. So fast forward. It says this Dorsey decision, which was of course a Supreme Court decision, because people appealed it. Some people were getting sentenced after Obama signed the law, and they still weren't getting the love. So they went to the Supreme Court to argue that, hey, we deserve it. And of course they won. And this is why the judge here is analyzing. This is a district court judge out of St. Louis. The Dorsey decision did not make a distinction between the original sentencing and resentencing after the FSA's effective date. Although there is no case directly analogous to the case here, several circuits have found Dorsey applies to resentencings. So, um, I want to fast forward to what the judge ultimately decided. What the court does find this positive is this: Holmes' case was remanded to this court after Congress found that in the First Sentence Act that Holmes' mandatory sentence of 120 months imprisonment for possessing 6.1 grams of crack cocaine was unfairly long. Under the Fair Sentence Act, such a small amount of crack cocaine would not have triggered a mandatory minimum of 120 months. After Congress made this finding in the FSA, but before the new sentencing guidelines took effect, this court issued an amended judgment sentencing Holmes again to 120 months imprisonment for possession with intent to distribute 6.1 grams of crack cocaine. But because the new guidelines had not taken effect when the court issued an amended judgment, the court did not have any authority to impose a post-act sentence on Holmes. Now Dorsey is held that the FSA applies retroactively to offenders whose crimes were committed before the effective date of the act, but whose sentencing occurred afterwards, including offenders who were sentenced before the new sentencing guidelines took effect. For these reasons stated in Dorsey, consideration of fairness, uniformity, and proportionality weigh in favor of applying the FSA's new lower mandatory minimums to post-act resentencing of Mr. Holmes. So, based on this, Judge Shaw, this was Judge Shaw, a great black judge, liberal black judge out of St. Louis. He reduced his sentence. I think he ended up getting 57 months instead of 120 months. And based on this conviction, Carlo Holmes, who is out of prison today, as of 2024, he's out of prison. Carlo Holmes was able to be released from his sentence within approximately a year. Now, mind you, he was on state parole when he caught the federal case and when he went through the situation. So he had to go through that. But as far as his federal sentencing time, the time that he had done on this charge, I am happy that I was able to help him get this done because he had no clue that he was even eligible for it. It was just a simple reading of the words sentence in his new judgment that came out after he won his appeal. Now, mind you, this is all done on the September 28th, 2010, when the new judgment came out. He just sat there in prison, didn't realize that, hey, I just got resentenced, but maybe I should get the new law. He didn't think about that till 6 months later because I pulled up on him and explained to him, hey, you are eligible for this. You need to file it. I remember the look on his face when I told him that. And guess what? He was able to get his sentence reduced. And he was able to get out of prison literally 5 years early, actually 6 years early, because he got it down to maybe 46 months, I believe, or something like that, somewhere around that time, or 57 months, somewhere around it. But it wasn't, if he didn't even get the full 5 years anymore, or 10. So this was a great situation. I'm really proud of. I was really proud of that case. I feel like that wasn't really that hard of a case to even beat or to get amended, because it wasn't about beating the case necessarily. It was more about getting the person what the Supreme Court said that they were eligible for. And he himself, he didn't even know he was eligible for it, but it was just a simple reading of the wording of the case. And when you read it, like I said, if you just skim over it, you may not even pay attention to it. This, if you look at your judgment and be like, hey, this is in September, but there a simple reading of the words that say the defendant is hereby committed to the custody of the United States Bureau of Prisons to be in prison for a total of 120 months. The defendant is sentenced on count 2. That very words of defendant is sentenced allowed him and gave him the statutory authority to go back in front of the judge and say, hey, I'm being sentenced now on September 28th. I got sentenced on September 28th. This is after Barack Obama signed the law on August 3rd, 2010. Give me the lower penalties because now I'm not subjected to the mandatory minimums anymore. And that's what he was ultimately able to do. He was able to get out of prison based on me doing that for him. And I was happy I helped him with it because really taught me a lot about myself. Sometimes it's not about the lawyer you have. It's not about how how much law school you've gone to. It's really just about a simple reading of the words of the case. That's really what it's about. It's really about that. And a lot of time when we just pick up a book and actually study and have the brain power to actually understand what we're actually reading, we go very, 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 very far when we actually do that. So, this case was Holmes versus the United States. This is his direct appeal. Anybody can look it up if they want to. It's Holmes versus the United States out of the Eastern District of Missouri. And here's the case number. So if anybody wants to look it up, they can look at that at any time. He was pro se on that. And I think they eventually, they eventually attached to him a lawyer to do it, to judge. But I don't even think he even needed it, because it was pretty clear as far as what he was eligible for. So yeah, this is a case I'm extremely proud of, and just moving forward, that's how I always attack cases. I look at the exact wording of the statute, of the judgment, of the commitment, and the words within the Constitution. So that was definitely one of my proudest moments. So anybody want any information as far as how you could be helped or assisted with your um, civil or criminal case, as a paralegal, as a person who's extremely knowledgeable and extremely experienced in these particular matters, I'm here to help. So you can reach out and make sure you become a member. And if you like this video, hit the thanks button on the video, and I'll catch you guys next time. Peace.